Good morning, Namaskar. This is Suraj Singh, civil engineer from Faridabad, NCR, Bharat. Namaskar, good morning. This is in connection with daily talk. Usually, I talk to you. Of course, it is one-sided, one-ended, but after all, talk is talk. You can write to me, and it's no problem. If you write to my mail, you can write. I'd be pleased to answer if I get time of that. I'll certainly find time to your questions, but still I don't get a single question from you people. I don't know why. It's in connection with our country, constitution of this country, which is well known. I've talked many videos. Our constitution is a great document. We all know constitution of Bharat, which we ourselves created. We are responsible for that. No one else is responsible. It is the biggest document in our country. This is having 395 articles in addition to having another schedules and annexures and all amendments. This is top document in the world, and even it's above Magna Carta of UK, and it's about US document, US Constitution of US. We should be proud. We should be proud. We should have a degree of highest degree of pride that we are having this document which rules us, for us, and by us. It's clearly topped by preambles, which is our soul of constitution and our soul of people of this country. That is preamble of constitution of this country. And there's another article that is 51A within this constitution, which enshrines, you can say, fundamental duties of its citizens, which is also very important. Though it was not originally included in this constitution in 1950, but later on, during emergency when Indira Gandhi was prime minister, these duties were added in addition to secularism and socialism were added on preambles. So whatever was added is okay, whatever is there is now acceptable. Preamble clearly says that this document is not a normal one. This document contains soul of our people. This document contains soul of our country, and I call this preamble as face of Bharat Mata. You may say that. Forget what Bharat Mata is. This is really Bharat Mata, and whole structure of constitution, whole contents of constitution can be termed as anatomy of Bharat Mata, anatomy of our body, national body, our Bharat Mata body. All contents are for all people of this country. No religion is mentioned in this constitution. No sects are mentioned. Rights are mentioned. Privileges are mentioned. Duties are mentioned. Positions are mentioned. And governments is mentioned. Government work is mentioned. Public is mentioned. So this document is a thorough one. Of course, not perfectly thorough, but thorough one, because there have been more than 100 amendments so far, and maybe more than 100 in the coming future. But we have to understand what our preambles in our spiritual sense, not word by word means. You have to understand expression of that, what it is. It clearly says, we people of this country, we people of Bharat, India, we people means all people. We people of Bharat, India, having solemnly resolved to constitute our country, our India, our Bharat into a sovereign, a, a sovereign, a secular, a socialist, a democratic, a republic. See, these parameters, these characters of ours, these properties of ours, we people of this country, Bharat, India, having resolved solemnly to constitute our country, Bharat, India, into a sovereign, secular, socialist, democratic republic, and to secure to its people, to secure to its people. It's secure. What is secure? It's not simply given. Secure means surety. To secure to its people, three levels. These are justice and liberty and opportunity. Equality, you may say equality. So three parameters are justice, liberty, equality. These are three main titles, headings, and heads, our heads. And justice does not mean justice from courts. It's social justice, is economical justice, and it is political justice. And liberty is liberty of thought, liberty of expression, liberty of belief, liberty of faith, and liberty of profession of religion or worship. It's clearly written worship. And equality of status and equality of opportunity. And this all leads to creation of fraternity among all people, to each individual of this country and all people, which takes you with mandate of no religion but mandate of citizenship, mandate of belonging to this country, which means is that. And this was done on 26th of November, whatever date I am not sure, whatever number is November 1949, and then we adopted this constitution, we enacted this constitution, and we gave to ourselves this constitution, which was a day in our history. Until today, this constitution has been on move to help us, to rule us, to take care of each and every citizen of this country from bottom to president of India level. we should be proud of this document, but many of us even don't understand about this document. It's, they don't even know. Many of us don't even know what is constitution of this country, what is Bharat ka Savidhaan, but it is there and it is mandated. It's mandatory for you, irrespective of fact that you know it or you don't know this. It applies to you, and all acts which were legislated pre 1947 and all acts following in post 1947 and now, they all come under umbrella of this document, Constitution of India Bharat. No act, no statute can be legislated which does not fall in compliance of provisions within this document, and that is most understandable thing. If something ultra vires to contents of this document, to articles of this document, that can be set aside by court. That is very clear. And this clearly says that we are responsible for our country, we are sovereign people, we are our luck writer, Bhagya Vidhata, you may say, Jan Gan Man Adhinayak Jayo Bharat Bhagya Vidhata. Jan is there, Gan is there, Man is there. We know what is Jan, what is Gan, what is Man. Jan Gan Man Adhinayak is there. We all are leaders. We are leaders ourselves, our political leaders. I am not talking of. I am talking of leaders of this nation, which is public. Public is leader of this nation. No king, no prime minister, and no president. Public is leader of this country. Public in collective form. Public is leader of this country, and we have to understand this analytically and synthetically both. We are public. We are responsible for our country. We have to protect this country. We have to take care of this country. It is we are responsible because we are owning this country. We have honored this country. We have honored all institutions of this country. We have honored all, for example, flag, national anthem, and whatever is there. We are responsible for this. We have to abide by constitution. We have to abide by law, and we have to abide by everything. We have to take care of all institutions which are here. We have to take care of social responsibilities, defense responsibilities, and we have to think of for what we got our independence. There is a background. That background is called ideals of this country, that for which we fought and struggled to get ourselves free, and that is called ideals of this. And we have to take care of nature, and we have to take care of science, and we have to take care of education, and we have to take care of society, and we have to take care of human rights. And we have to take care of everything, and you take care of whatever is required there. There is all defined within duties, fundamental duties in the article. So I'm just expressing it. I'm not going to read that because that reading always takes time, and you people say every time you're reading word by word. I'm just expressing to you what is required. We should understand fundamental duties are of paramount importance, because if you don't do work, you will not get paid, you will not get any result. So first you have to do national duty, and it's called fundamental duty. That's very, very important. After that, you will claim your rights, the privileges which are included in enshrined in constitution of this country, and which are very important for each and everyone. Without that also you cannot move. No injustice can be caused to you. Your liberty cannot be stolen, and your rights cannot be, you can say, made void. But it's happening nowadays. For example, we take case of this current situation. I will go to constitution little back. I'm just going to refer to your current status of Jammu and Kashmir, which is very, very burning issue, and this can change so many things in future. Because this is very, very specific issue. Every time I'm telling you, you have to understand that. Yesterday I just browsed this our prime minister's address to nation, and I'm not happy with that. Really, I'm not happy. Question is not this you are going to develop it or you are going to develop. That is your duty. You cannot claim that I'm being specific. PM must understand this is part of duty of government and PM and all, that you have to develop every area of this nation, not only Jammu and Kashmir. And don't say I'll spend money, it will develop and this and that. This means you are talking in a similar pattern, the same pattern as Israel talks and US talks regarding your Palestine, Egypt and Syria. We are not interested in that, and people of Jammu and Kashmir are also not interested in that. You're talking to someone indirectly that I give you money and you do whatever what I say. It's a question of country, question of state, question of belongingness, question of rights. You cannot purchase rights of people. Till now, whatever happened in J and Kashmir since 1947, what was wrong? You could spend money there also, and you spend money, but you are saying there is corruption, there is the terrorism, and there is no advancement, and that is why you scrapped Article 370. Is that a relevant reason? If there was corruption, what were you doing? My question is that you were in state government. If there was existence of corruption, what did you do? If there is terrorism, what did you do? You think article was creating terrorism? You think article was creating corruption? This is complete befooling people of this country and befooling yourself. EVM, Mr. Prime Minister, you are lying to yourself. You are not doing service to your own acts. This is wrong. You are just whitewashing your black fans. That's all, nothing else. Article is just a paragraph. It doesn't stop removal of corruption. It doesn't stop taking care of state. It doesn't stop taking care of all other issues. There's many similar articles exist for other states as well. Last month you just did something for Nagaland. While you do similarly reverse there, you allowed their flag, you allowed their documents, travel documents and all. Why did you allow for that country? While you're saying it should be similar uniform, it's not uniform then. I am not criticizing you, Mr. Prime Minister and Mr. All. I am just telling you facts. You did not tell. You are telling what will happen. You will feel happy and you will I'll revert decision of the state. Why did you do in first place? If you want to say, you are telling public that I shall reverse decision when it resumes normalcy, again it will become a state. Then why did you change it to union territory? What was the reason for that? What is the reason for that? This is childish talk you made. I listen. People will develop that. People will develop or not develop. Development is another issue. It has nothing to do with this article. If you have to develop, you can develop. If you don't want to develop, don't develop. There's nothing to do with article. Article is something else. Article pertains rights and soul of people. Articles, it is Article 370 is something reflected into Constitution. This is not original idea. Reflected to sense this was imported based on some other document which was international document, and name of that document is Instrument of Accession to State of Jammu and Kashmir, to India. Instrument of Accession of Jammu and Kashmir of State of Jammu. At that time it was all state. So Kingdom of Jammu and Kashmir, you can say accession of Kingdom of Jammu and Kashmir to nation India-Bharat. That instrument is mandating this. You know it very well or you don't know it very well, I am not sure. According to directions, I feel that I calculate, in fact, not feel, that you did not read or understand such document. You are just watching, you are just reading, you are just reviewing Article 370 and CO 48 1954, which was sequent results of that article of this article of service, Instrument of Accession, Kingdom of Jammu to Bharat, India. You can say anything. I just tell yesterday also, and again I am repeating that article of accession, one document, Article 370 inculcated into Constitution, inserted into Constitution, and CO 48 1954 again inserted into Constitution as an instrument application, as a base of application of our Constitution into Jammu and Kashmir state now. That was the CO48, which you have scrapped or you have replaced by something else. These are three, you can say, titles, locations which apply to us, Bharat. Out of these three, instrument accession is an international status document because two signatures are there. One signature is the Kingdom of Jammu and Kashmir, that is nation, and another is India as nation. You can say two signatures, two nations. This is document signed and agreed by two nations, a contract agreed by two nations. So at that time, this was international document, and still it is an international document. It has not been repealed. Based on this international document, we got inserted Article 370 and CO48 1954 into our Constitution. Other than this, there are disputes-based documents. Disputes-based. One document is UN resolution in relation to Jammu and Kashmir, which was done in 1947, 48 I show, number 47, UN resolution, and then it was later on Simla agreement 1972, and then it was Lahore declaration. These two documents, Simla agreement and UN resolution, are disputed based documents, but they are of international nature. Simla agreement was executed between two nations, Pakistan and Bharat. This is bi-national document, bipartite document, and UN resolution is what document? It is not even, it is world document, UN resolution, because it was resolved and decided by world body, and that is UN. So one is world document, one is bipartite document, and then declaration during Atal Bihari Vajpayee Saab, and that is also, you can say, a bipartite declaration. So my reading now is, my debating point is, what is position of these documents? Let us say documents that apply onto us and Kingdom of J&K, that is instrument of accession, and documents which are internal to us, that is 370 and CO48. You have scrapped 370 and 48 1954 CO48. You have scrapped these two. I don't mind that. You have scrapped 370 and you have replaced CO48 with another one, which is very simple in nature, which is nothing to do as it was originally, which simply says that Constitution of India applies onto state of J&K, which is no more state now, which is union territory. That is your view, our view. We can change whatever we want. But at the same time, you are saying that Article 370 has gone from this CO48. That is also no problem. These two do not create problem as far as they are concerned. But we have to see what is sequential rights that have gone, how public has suffered, we have to see that. And then question is that you, in your address, you did not define on what basis you took decision, you raised this decision. My question is only this, that 370 has gone, no problem. CO48 has gone, no problem. And I'm at this stage not talking of resolution of UNO and similar agreement I'm talking, and I'm also talking Lahore declaration. But my issue is, my consideration is, what is status of instrument of accession Kingdom of Jammu and Kashmir to nation Bharat? That is my 370, I'm not going 48. Because depending on the existence or non-existence of this document now, or validity or not being valid of the document now, these articles shall answer this scrap, or you can say mandated removal of these, or you can say annulment of these documents 370, not documents, I can say articles 370 and C48 will define what status it is. My first question is instrument of accession of Kingdom of Jammu and Kashmir to Bharat, India, valid today after the scrap of Article 370 and CO48, or instrument of accession Kingdom of JNK to Bharat, India is not valid now after step of Article 370 and CO 48. These questions must be answered, and Prime Minister did not answer these questions. Parliament did not answer these questions. Public did not answer these questions, and nobody knows about this answer because in both way, if it is valid, there is one sequential result, and if it is not valid, there is one sequential result. Both results are different. We have to analyze those values of difference, contents of difference. Let us say contents of first document, that is international document, accession of Jammu and Kashmir Kingdom to us, which is very clearly defined in 2 pages. You can read that one, that they access to us, Hari Singh access to us conditionally. He didn't access absolutely. Had he accessed absolutely, there would have been no problem. They access to us conditionally, and those conditions were confined to 3 parameters, and one parameter was that Bharat shall remain responsible on behalf of the state of J&K for 3 or 4 points. One point was defense services, second point was external services, external affairs ministry, and one was your, you can say, communication, etc. There are 3 or 4 points, and these are telegraph and railways and this and that, so many issues are there. These were there. So elections, conduct of elections also is there. These 4 points were allowed to India Bharat by Kingdom of J&K, that you take care of this on our behalf. We are coming to your state to be a part of your country, and we are happy conditionally. And also in this it is clearly mentioned that because at that time there was no constitution of Bharat in 1947, it would have evolved after few years. So it was clearly mandated by King that your future constitution, whatever it would be, it is not necessary that we accept that or we don't accept that. That is up to us. It's our prerogative in future. What shall we think of that? As of today, we don't recognize that, and we shall accept this document only as our prime constitution. And we don't allow, according to this document, that you change something out of these contents or scripts. You cannot do anything on that. Whatever you have to do for remaining topics, remaining parameters, remaining entries, we shall take care of ourselves, and you are known to pinpoint that. No act of your country shall apply onto us without our consent of our assembly. And Constituent Assembly was there, which was dissolved later on, but this document is like that. If you want to buy land, in our state, you can buy land through us, not directly. If you want land, you tell us, we will get it acquired and hand over to you. If you want land under custody of government of state of J&K, you ask us, we shall give you that land based on agreed prices. This is clearly mentioned in that instrument of accession. That is what I say every time. Young generation, please understand, read document, but you are not thinking. Engineers, doctors, professors, whatever, highly qualified people are not thinking. They are not reading, public is not reading, and they are just in dry, this will happen and that happen, without having knowledge background. They don't even talk of that, and they are claiming experts about that. You go on TV channels, you will find everybody is expert nowadays, every citizen, but if they don't understand what they are talking, that's the problem. They don't understand what they are talking, but they're talking and shouting and crying in high pitch, everything, and for hours and hours together. This is character of people knowing nothing and talking everything. Well, it's their choice. My submission to you is, my submission to nation and to government is, I want to know on behalf of public, what is legal status of instrument of accession today, after you have disapproved Article 370 and CO 48, which you have replaced by new CO 2019. Now my question is very different, because it leads to some other considerations, some other results, and that is a very dangerous in sense. As I said, I'm not talking of UN resolution in this immediately. I'll take it little after a while. If this document is valid, Mr. Prime Minister or Mr. President, If this document is valid, what does it mean? If this document is valid, this means all contents in that are valid, all contents, and that means you could not change anything without approval of people of JNK or Constituent Assembly or legal status, or you can say assembly now. Though it is dissolved, but assembly would be there in future. But you change without considering anything and assuming that parliament is assembly, which is not acceptable. Parliament MPs do not represent the state of Jammu and Kashmir. No one is there from Jammu and Kashmir. So representation is void, and when the representation is void and that is not assembly, assembly is not existing, and you have taken decisions against that, instead of accession, your decision is void, even though it is approved by parliament, because parliament has got no power to approve some law related to Jammu and Kashmir state according to the constitution of this country. Without their approval, because their approval is higher than parliament. Parliament is lower to state of Jammu and Kashmir, assembly. This is an illegal act, whatever you done. Annulment of Article 370 and annulment of 48 are both illegal. This is no value at all. The status quo remains as previous. Another point is, which is very, very difficult to answer, and it can lead to unknown areas. If that document is not valid, that is a major point. If that document is not valid, what does it mean? Can you think of? Can you analyze what does it mean? I have a small mind and I am a very small person. I am not a big person. I am just a professional, nothing else. I am not a politician. I am not industrialist. I am not lawyer. I am not judge. I am a common person having common thinking, common mind, common contemplation, and I cannot think only to that level. I cannot think beyond that. There are many, many professors, many, many researchers who are much, much, much more higher than me. But though I am a small person and having a small mind, my question is also very small, though it may have highest degree of concentration. Question is, if that document is illegal now or invalid now, how we should check it? Prime Minister did not tell, President did not tell, and Parliament did not tell. What is the status of this document, whether it is live or it is dead? I consider it as dead because you have removed Article 370 and CO Order 48 linked to this document. If document is dead, there is no value of document, instrument of accession, which said, which contented and which empowered access of Jammu and Kashmir Kingdom to our republic. If that document is dead, this means that accession is also dead. Right or wrong? And when accession is dead, every content of that document is dead. Right or wrong? This means by virtue of that, that international document and instrument of accession, execution, we got some portion, we got full portion of that country to ourselves. I am calling country because this was JNK was country that time. It came to us as country and then stayed with us as country. I can say a state because they stayed with country, but because they didn't merge with us, they just stayed with us as friends legally. If that document does not exist, what we should say that this JNK state which we are calling now or which we have done converted to union territory, this means this does not exist for India. This does not now constitute as part of our country. You mean to say that? You did not say that, but you mean to say that. It is understood. This means when this document is dead and this land has gone out of your control, what shall you do? Indirectly saying, you are now occupying a country, or you can say it is equivalent to invasion to another country. Because You have no right to own that country or rule that country without mandate of people of that country. And there is no mandate. To just suppress them, to just suppress them from asking questions, from raising questions against you, you have fenced them. You have fenced whole state, Kashmir particularly. You have fenced that. So that people should not come to fight with us. Okay? So we have to know answer. If this document is dead, means whatever actions you have taken are dead. It doesn't matter whether 360, 370 is there or it is not there. It doesn't matter whether other articles apply or not apply. CO48 is there or no. New plus is also not compelled, not legal. It's not applicable because that document is dead. Unfortunately, our ministers, our leaders, our political parties, all are in the same boat. They do corruption everywhere, some on a small level and some on large level. That doesn't work. I don't know who shall give answer to this. Maybe court asked later on. The court would certainly ask the first status of document because that document creates 370. That document creates 370 SC order 48,954. And then till now we did not talk of Pakistan because Pakistan is nowhere in picture there. Pakistan is not there picture in instrumentalization. It's not in picture in Article 370, and it's also not in picture in CO48. So we are there separate, independent of Pakistan. But when dispute attracts the import dispute between two nations in Pakistan and Bharat, then it comes into picture. And of course dispute is there. Dispute is there. That is UN resolution. Both countries claim JNK. We claim and they claim. We may say anything, this belongs to us. Saying doesn't solve anything. United Nations do not say yet that Kashmir belongs to us. It never says yes. Never said. Still, status is that there is a dispute and both countries have to sit together and talk. Why should they say like that? If Kashmir belongs to us, absolutely to us, no other person is seeking ownership of that. This means we have to sit there, we have to work out and wait for our time and say yes, this is what it is. Dispute says there are two parties in this dispute, one is India and one is Pakistan. This one's what? And also then on dispute resolution, similar agreement came, which was executed between India and our people, our country. There Pakistan is involved. You cannot say it's absolutely internal matter then. No. Because this triangle of instrumentalization, 370 and C order, goes to another link of another triangle. Then there is similar agreement. And similar agreement holds in execution of instrument resolution, but it holds only. It doesn't say it is repealed, just like it. It only holds. It's not repealed. So we have to understand this fact. Just again getting excited, shouting does not solve our problem. We have to check for our awakening, our standards in UNO, what level we are there, because UNO is alive, they are not dead. There is complete misinformation by Government of India in this connection. You may call it misinformation, or you may call it concealing information, whatever you may say, this has happened, and we cannot save ourselves. Pakistani are in their own world now. They want to war and let this war. They want to capture this area and that area, this and that area. Just like our people are thinking, we will get Lahore. All this 11 talks and people talk like that. Unfortunately, we are talking like that. Should not be that way. So then what should be done? People of our today, we don't know what actually changes are. We only know that there are changes in Article 370 and there are changes in CO48. But really, we don't know what these changes are for. Like children, we can say, "Oh, it was removed. Very good. Thank you. It's very good. You have done what you could have done in 70 years." You think people in last 72 years were fools? Those leaders were fools. They didn't understand the implication of law. Only you are so intelligent. Modi is very intelligent. Amit Shah is very intelligent. All are fools. Indira Gandhi was fool. Jawaharlal was fool. And VP Singh was fool. And Gujral was fool. And Chandrasekhar was fool. Everybody was fool. Only one person. That is Modi. He is intelligent. He understands everything. It is a question. You are doing something, the Prime Minister Indian Modi, that which you don't understand. Simply saying Netanyahu-based statements, Netanyahu statements of Israel that we can buy this through US, this would not work in our country. You are saying we will give this facility, we will develop this area, we will develop that area. Development goes on. Everybody knows. You have to do that. You cannot deny you are taking money from people in tax forms, in GST forms. You think that you take care of people, but you are not. You are just creating an atmosphere which cause bad images on people, bad act of people. This may call unrest and demonstrations, and now people are in jail in Jammu and Kashmir. There's created jail. One day they come out, you will see facts. Means whether they are happy or they are not happy. That time will tell. But now we are not talking about that. We are talking about legal applications. And legal implications are that I am not sure at least what you have done. I am not sure. I have full right to know because I am Bharatvasi, I am citizen of this country. I have an absolute right to know what government has done. But you don't want to tell people that what government has done, and that is the difference. That is the difference only. You are calling your BJP as party with a difference. Of course, BJP was with a difference, but your defense is like that is completely useless. Well, I just wanted to know what status this instrument accession has. Now, I will go to a part of constitution again because this discussion cannot end otherwise. We have to now see certain provisions of related provisions. We can say temporary translation and specific provisions. These are here in the constitution, and I will just read them slowly so that people understand. I start with part 21, which is temporary translation and special provisions, and it is Article 369. Article 369, which reads as I'm just speaking, quoting, uh, notwithstanding, notwithstanding anything in this constitution, Parliament shall, during a period of 5 years, yeah, please stand now better. I'll stand so that I can speak better. Let us see speak. That's okay. Difficult to sit and speak. Okay. Notwithstanding anything in this constitution, Parliament shall during a period of 5 years from commencement of this constitution have power to make laws with respect to following matters as if they were enumerated in concurrent list, namely trade and commerce. Trade and commerce within a state in production, supply, and distribution of cotton and woolen textiles, raw cotton, including ginned cotton and unginned cotton or kapas, cotton, seed, paper, including newsprint, foodstuffs, including edible oilseeds and oil, cattle fodder, including oil cakes and other concentrates, coal, including coke and derivatives of coal, iron, steel, and mica. B. Offences against laws with respect to any of matters mentioned in Clause A, jurisdiction and powers of all courts except Supreme Court with respect to any of those matters, and fees in respect of any of those matters, but not including fees taken in any court. Yes. But any law made by Parliament, which Parliament would not but for provisions of this article have been competent to make shall to extent of incompetency cease to have effect on expiration of said period, except as respect things done or omitted to be done before expiration thereof. Article 370, which is very burning in these days. This is very burning article. Number one, notwithstanding anything in this constitution, provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Power of Parliament to make laws for said state shall be limited to those matters in union list and concurrent list which in consultation with government of state are declared by president to correspond to matters specified in instrument of accession governing accession of state to dominion of India as matters with respect to which dominion legislature may make laws for that state. I speak again, read again, this is very important. Those matters in union list and concurrent list which in consultation with government of state are declared by president to correspond to matters specified in instrument of accession governing accession of state to dominion of India as matters with respect to which dominion legislature may make laws for that state, and such other matters in said list as the concurrence of government of state president may order specify. Explanation. For purpose of this article, government of state means person for time being recognized by president as Maharaja of Jammu and Kashmir, acting on advice of Council of Ministers for time being in office under Maharaja's proclamation dated 5th day of March 1948. Provisions of Article 1 and of this article shall apply in relation to that state. Such are other provisions of this constitution shall apply in relation to that state subject to such exceptions and modifications as president may by order specify, provided that no such order which relates to matters specified in instrument of accession of state referred to in paragraph 1 of subclause B shall be issued except in consultation with government of state. Provided further that no such order which relates to matters other than those referred to in last preceding proviso shall be issued except with concurrence of that government. If concurrence of government of state referred to in paragraph 2 of subclause B of clause 1 or in second proviso to subclause D of that clause be given before Constituent Assembly for purpose of purpose of framing Constitution of state is convened, it shall be placed before such assembly for such decision as may take thereon. Notwithstanding anything in foregoing provisions of this article, President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that recommendation of Constitutional Assembly of State referred to in clause 2 shall be necessary before President issues such notification. This is Article 370, which clearly mentions instrument of accession governs this access to Bharat, India, and that there is Constitutional Assembly, and that President can sign something based on Constituent Assembly or Assembly. That is what it says. Though this article has been scrapped out, but the court says this is power of this article, which I wanted to let you know about this. Then let us go further. This is regarding Jammu and Kashmir. Means whatever I am asking for is there. Two places, two locations given instead of session, and without Constitutional Assembly and government of that state, no changes, no modifications, no amendments could be made to this article, but they have done it completely scrapped, which is not acceptable to me as an individual. Now let us go to 371, that is state of Maharashtra and Gujarat. It's not simply Jammu and Kashmir. It is state of Maharashtra and Gujarat also. So let's say notwithstanding anything in Constitution, President may by order made with respect to state of Maharashtra, Gujarat, Maharashtra or Gujarat provide for any special responsibility of governor for a establishment of separate development boards for Vidarbha, Marathwada and rest of Maharashtra, or as case may be Saurashtra, Kutch and rest of Gujarat, with provision that a report on working of each of these boards will be placed each year before state legislative assembly. Then equitable allocation of funds for developmental expenditure over said areas subject to requirements of state as a whole, and an equitable arrangement providing adequate facility for technical education and vocational training and adequate opportunities for employment in services under control of state government in respect of all said areas subject to requirements of state as whole. Article 371A, special provision for Nagaland. Notwithstanding anything in this constitution, no act of parliament in respect of religious or social practices of Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, ownership and transfer of land and its resources shall apply to state of Nagaland unless Legislative Assembly of Nagaland by a resolution so decides. Governor of Nagaland shall have special responsibility with respect to law and order on the state of Nagaland for so long as in his opinion, internal disturbances occurring in Naga Hills, Tuensang area immediately before formation of that state, continue therein or in any part thereof, and in discharge of his functions in relation thereto. Governor shall, after consulting Council of Ministers, exercise his individual judgment as to action to be taken, provided that if any question arises whether any matter is or is not a matter as respects which governor is under this subclause required to act in exercise of his individual judgment, decision of governor in his discretion shall be final, and validity of anything done by governor shall not be called in question on ground that ought or ought not to have acted in exercise of his individual judgment. Provided further that if President on receipt of a report from Governor or otherwise is satisfied that it is no longer necessary for Governor to have a special responsibility with respect to law and order in state of Nagaland, he may by order direct that Governor shall cease to responsibility with effect from such date as may be specified in order. In making this recommendation with respect to any demand for a grant of Governor of Nagaland shall ensure that any money provided by Government of India out of Consolidated Fund of India for any specific service or purpose is included in document demand for a grant relating to that service or purpose, and not in any other demand as from such date as Governor of Nagaland may by public notification in this behalf specify, then there shall be established a regional council for Tuenseng district consisting of 35 members, and Governor shall in his discretion make rules providing for composition of regional council and manner in which members of regional council shall be chosen, provided that deputy commissioner of Tuenseng district shall be chairman ex officio of regional council, and vice chairman of regional council shall be elected by members thereof from amongst themselves. Qualifications for being chosen as and for being members of regional council, terms of office of and salaries and allowances of, if any, to be paid to members of regional council, term of office and salaries and allowances, if any, to be paid to members of regional council, procedure and conduct of business of regional council, procedure and conduct of business of regional council, appointment of officers and staff of regional council and their conditions of services, and any other matter in respect of which it is necessary to make rules for constitution and proper functioning of regional council. Notwithstanding anything in this constitution, for a period of 10 years from date of formation of state of Nagaland, or for such further period as governor may, on recommendation of regional council, by public notification specify on this behalf, in this behalf. Administration of Tuenseng district shall be carried on by governor. Where any money is provided by government of India to government of Nagaland to meet requirements of state of Nagaland as a whole, the governor shall in his discretion arrange for an equitable allocation of that money between Tuenseng district and rest of state. No act of legislature No act of legislature of Nagaland shall apply to Tuenseng district unless governor on recommendation of regional council by public notification so directs, and governor in giving such direction with respect to any such act may direct that act shall in its application to Tuenseng district or any part thereof have effect subject to such exceptions or modifications as governor may specify on recommendations of regional council. Provided that any direction given under this subclause provided that any direction given under this subclause may be given so as to have retrospective effect. Governor may make regulations for peace, progress, and good governance, government of Tuenseng district, and any regulations so made may repeal or amend with retrospective effect if necessary, any act of parliament or any other law which is for time being applicable to that district. One of members representing Tuensing district in Legislative Assembly of Nagaland shall be appointed Minister for Tuensing Affairs by Governor on advice of Chief Minister, and Chief Minister in tendering advice shall act on recommendations of majority of members as aforesaid. Minister for Tuensing Affairs shall deal with and have direct access to Governor on all matters relating to Tuensing district, but shall keep Chief Minister informed about same. Notwithstanding anything in foregoing provisions of this clause, final decision on all matters relating to Tuensing district shall be made by Governor in his discretion. In Article 54 and 55 and Clause 4 of Article 80, references to elected members of Legislative Assembly of a state or to each such member shall include references to members of Legislative Assembly of Nagaland elected by regional council established under this article. Now, in Article 172, clause I clause 1 shall, in relation to Legislative Assembly of Nagaland, have effect as if for word 60, the word 46 had been substituted. Well, that's something else. In said clause, reference to direct election from territorial constituencies in state shall include elections by members of regional council established under this article. In clause 2 and 3, references to territorial constituencies shall mean references to territorial constituencies in Kohima and Mokokchung districts. If any difficulty arises in giving effect to any of foregoing provisions of this article, President may by order do anything, including any adaptation or modification of any other article which appears to him to be necessary for purpose of removing that difficulty, provided that no such order shall be made after expiration of 3 years from date of formation of state of Nagaland. Explanation: in this article, Kohima, Mokochung and Tuensing districts shall have same meaning as in state of Nagaland Act 1962. Then it is 371B, which applies to Assam. Let me sit for 5 minutes and then see. Yes. I have some problem in eyes. I cannot. The problem is reading. Reading is a problem for me. Yes, it's a really problem. Yeah. 371B, notwithstanding anything in Constitution, President may, by order made with respect to state of Assam, provide for constitution and functions of a committee of Legislative Assembly of state consisting of members of that assembly elected from tribal areas specified in Part 1 of table appended to paragraph 20 of 6th schedule, and such number of other members of that assembly as may be specified in order, and for modifications to be made in rules of procedures of that assembly for constitution and proper functioning of such constituencies. Article 3C, 371C, State of Manipur. Notwithstanding anything in this constitution, President may, by order made with respect to state of Manipur, provide for constitution and functions of a committee of Legislative Assembly of a state consisting of members of that assembly elected from hill areas of that state for Modifications should be made in rules of business, of government, and in rules of procedures of legislative assembly of state and for any special responsibility of governor and order to secure proper functioning of such authority. 2. Governor shall annually or whenever so required by President make a report to President regarding administration of hill areas in state of Manipur and executive powers of Union shall extend to giving of directions to state or as to administration of said areas and is explained as follows. In this article, expression hill areas means such areas as President may by order declare to by hill areas. Article 371D, which is Andhra Pradesh. Ah, yes. President may by order made with respect to state of Andhra Pradesh provide having regard to requirements of state as a whole for equitable opportunities and facilities for people belonging to different parts of state in matter of public employment and in matter of education, and different provisions may be made for various parts of state. An order made under clause 1 may be particular, require that state government organize any class or classes of posts in civil services of or any class or classes of civil posts under state into different local codes cadres for different parts of state and allot in accordance with such principles and procedures as may be specified in order to persons holding such posts to local cadres and so organized. Specify any part or parts of state which shall be regarded as local area or local area. For direct recruitment to propose in any local cadre, whether organized in pursuance of an order under this article or constituted otherwise under state government. For direct recruitment to propose in any cadre under any local authority within a state and for purposes of admission to any university within state or B or to any other educational institution which is subject to control of state governance. For purpose of admission to any university within state or to any other educational institution which is subject to central of state government, control of state government. Specify extent to which, manner in which, and conditions subject to which preference or reservation shall be given to given given so be it or be it. In matter of direct recruitment to post in any such cadre referred to in sub clause B as may be specified in, in manner of direct recruitment to post any such cadre referred to in sub clause as may be specified in the behalf of order. In matter of admission to any such university or other educational institution referred to in subclause as may be specified by this behalf in or in matter of admission to any such universities or other educational institutions referred to in subclause B as may be specified in this behalf in order to or in favor of candidates who have resided or studied in for any period specified in order in local areas in respect of such cadre universities or old educational institutions as case may be. President may by order provide for constitution of an administrative tribunal for state of Andhra Pradesh to exercise such jurisdiction, powers and authority including any jurisdiction, any such exercise such jurisdiction, powers and authority including any jurisdiction, power and authority which immediately President may by orders provide for a constitution of an administration tribunal for the state of Andhra Pradesh to exercise such jurisdiction, powers and authority. Hmm. Including any jurisdiction, power and authority, including any jurisdiction, power and authority, which immediately before commencement of this Constitution, 32nd Amendment Act 1973, was exercisable by any court other than Supreme Court or by any tribunal other or other authority as may be specified in order with respect to following matters, namely appointment, allotment or promotion to such class or classes of posts in any civil service of state or to such classes or classes of civil posts under state or to such class or disease class or classes of posts under control of any local authority within state as may be specified in order. Seniority of persons appointed, allotted or promoted to such class or classes of posts in any civil services of state or to such classes or classes of civil posts under state or to such class or classes of posts under control of any local authority within state as may be specified in order. Such other conditions of service of persons appointed, allotted or promoted to such class or classes of posts in any civil service of state or to such class or classes of civil posts under state or to such classes or classes where classes of posts under control of any local authority within state or state as may be specified in order. An order made under clause 3 may authorize administrative tribunal to receive representations for redress of grievances relating to any matter within its jurisdiction as President may specify in order and to make such orders thereon as administration tribunal deems fit. Contain contains such provisions with respect to powers and authorities and procedures of administrative tribunal, including provisions with respect to powers of its administrative tribunal to push for contempt of itself as President may deem necessary. Sorry. Provide for transfer to administrative tribunal of such classes of proceedings being proceedings relating to matter within jurisdiction and pending before any court other than Supreme Court or tribunal or only authority immediately before commencement of such order as may be specified in order. Contains such supplemental, incidental, and consequential provisions, including provisions as to laws and as to limitation or independent evidence or for application of any law for time being as force, subject to any exceptions or modifications as President may also provide. President may also deem necessary. Order of administrative tribunal finally disposing all case shall become effective upon confirmation by state government or on expiry of those months from from due date on which order is made in whichever is earlier, provided that state government may be special, provided that state government may by special order made in writing and for reasons to be specialized specified. Therein modify or annul any order of administrative tribunal before it becomes effective, and as such in such a case the order of administrative tribunal shall have a effect only in such modified form or be of be of no effect, as case may be. Every special order made by state government under provision to clause 5 shall be laid as soon as may be after it is made before both houses of state legislature. High Court for state shall not have any powers of superintendence over administrative tribunals, and no court other than Supreme Court or tribunal shall exercise any jurisdiction, powers, or authority in respect of any matter subject to jurisdiction, power, or authority of or in relation to administrative control. If President is satisfied that continued existence of administrative tribunal is not necessary, President may by order abolish administrative tribunal and make such provisions in such order as he may now defeat fit for transfer and disposal of cases but pending before tribunal immediately before such abolition. Nothing, notwithstanding any judgment, decree, or order of any court, tribunal, or other authority, notwithstanding any judgment, decree, or order of any court, tribunal, or other authority, no appointment, no appointment, posting, promotion, or transfer of any person made before first day of November 1956 to any post within state of Hyderabad as if existing before that date. Made before commencement of this Constitution, 32nd Amendment Act 1973 to any post under government or any local or other authority within state of as state of Andhra Pradesh and mm, made before commencement of this Constitution, 32nd Amendment Act 1972 to any post under government or any local or other authority within the state of Andhra Pradesh and no action taken or thing done by or before any persons referred to in subclause A shall be deemed to be illegal or void or ever to have become illegal or void merely on ground that appointment, posting, promotion, or or promotion or transfer of such persons was was not made in accordance with any law, then enforce providing for any requirement so as to residence within state of Hyderabad or as case may be within any part of state of Andhra Pradesh in respect of such appointment, posting, promotion or transfer. Provisions of these articles and of any other article made by President thereunder shall have effect notwithstanding anything an area any other areas. Now provision of the article and of any order made by President hereunder shall have effect, notwithstanding anything in any other provisions of this Constitution or in any other allowance. Now we'll go to Article 371E, which is establishment of central universities in Andhra Pradesh. Article 371E. Parliament may by law provide for establishment of university in state of Andhra Pradesh. 371F. Notwithstanding anything in this constitution, Legislative Assembly of State of Sikkim shall consist of not less than 30 members. As from date of commencement of constitution, if 1975, hereinafter in this article referred to as appointed day, Assembly in Sikkim, Assembly for Sikkim formed as a result of elections held in Sikkim in April 1974 with 32 members elected in said elections, hereinafter referred to as the Assembly for Sikkim formed as a result of elections held in Sikkim in April 1974 with 32 members elected in said elections, thereafter referred to as sitting members, shall be deemed to have been the Legislative Assembly of State of Sikkim duly constituted under this constitution. Sitting members shall be deemed to be members of Legislative Assembly of State of Sikkim duly elected under this constitution. Said Legislative Assembly of State of Sikkim shall exercise powers and perform functions of Legislative Assembly of a state under this constitution. In case of assembly deemed to be Legislative Assembly of the State of Sikkim under Clause B, the references to the period of 5 years in clause of Article 772 shall be construed as references to a period of 4 years, and said period of 4 years shall be deemed to commence from appointed day. Until what is this here? I see. Until other provisions are made by Parliament by law, there shall be allotted to the state of Sikkim one seat in House of People, and state of Sikkim shall form one parliamentary constituency to be called Parliamentary Constituency for Sikkim. Representative of state of Sikkim in House of People in existence on appointed day shall be elected by members of Legislative Assembly of State of Sikkim. Parliament may, for purpose of protecting rights and interests of different sections of population of Sikkim, make Parliament may, for purpose of protecting rights and interests of different sections of population of Sikkim, make provisions for member of seats in Legislative Assembly of State of Sikkim, which may be filled by candidates. Parliament purpose of protecting rights and interests of different sections of population of Sikkim make provisions for number of seats in Legislative Assembly of State of Sikkim, which may be filled by candidates belonging to such sections and for determination by system. Okay. Mm. Belonging to such sections alone may stand for elections in Legislative Assembly at State of Sikkim. Government of Sikkim shall have special responsibility for peace and for equitable arrangement for ensuring social and economic advancement of different sections of population of Sikkim, and in discharge of his special responsibility under this clause, the government as clause government as clause government, where is this? Yeah, governor. Once again, should read this. Let us see. Government of Sikkim shall have special responsibility for peace and for an equitable arrangement for ensuring a social and economic advancement of different sections of the population of Sikkim, and is in discharge of his special responsibility under clause, Governor of Sikkim shall subject to such directions as per President may from time to time deem fit issue act in his discretion. All property and assets, whether within or outside territories comprised in the state of Sikkim, which immediately before appointed day were vested in government of Sikkim or in any other authority, or in any person for purpose of government of Sikkim shall, as from appointed day, vest in the government or government of state of Sikkim. Okay. High Court functioning as such immediately before appointed day in territories comprised in state of Sikkim shall on and from appointed day be deemed to be High Court for State of Sikkim. All courts of civil, criminal, and revenue jurisdiction, all authorities and all officers, judicial, executive, and ministerial throughout territory of State of Sikkim shall continue on and from appointed day to exercise their respective functions subject to provisions of this constitution. All laws in force immediately before appointed day in the territory's knowledge as all laws in force immediately before the appointed day in territories comprised in the state of Sikkim or any part thereof shall continue to be in force therein until amendment amended or repealed by a competent legislature or uh, or other competent authority for purpose of facilitating application of any such law as is referred to in clause K in relation to administration of state of Sikkim, and for purposes of bringing provisions of any such law into accord with provisions of this I think we should continue. For the purpose of facilitating application of any such law as is referred to in Clause K in relation to administration of state of Sikkim and for the purpose of bringing provisions of any such law into accord with provisions of this constitution. President may within 2 years from appointed day by order make such adaptations and any okay. President may within 2 years from appointed day by order make such adaptations and modifications of law, whether by way of repeal or amendment, as may be necessary or expedient, and thereupon every such law shall have effect subject to adaptations and modifications so made, and any such adaptations or modifications shall not be questioned in any course of inquired law. Neither neither Supreme Court nor any other court shall have any jurisdiction in respect of any deceit, dispute or other matter arising out of any treaty, agreement, engagement or other similar instruments relating to Sikkim which was entered into and executed before appointed day, and to which Government of India or any of its predecessor governments was a party, but nothing in this case is in. Okay. Engagement or other similar instrument relating to Sikkim which was entered into or executed before appointed day, and to which Government of India or any of predecessor government was a party, but nothing in this clause shall be construed to derogate from provisions of Article 14. President may by public notification extend with such restrictions or modifications as think fit to the state of Sikkim any enactment which is in force into the state of India at date of notification. If any difficulty arises in giving effect to any of foregoing provisions of this article, President may by order do anything, including any adaptation or modification of any other article which appears to him to be necessary purpose of of removing that difficulty. Provided that no such order shall be made after expiry of 2 years from appointed day. If things done and all actions taken in or in relation to state of Sikkim or territories comprised therein during period commencing on appointed day and ending immediately before date on which Constitution signed in 1975 receives all assistance of the on this day, on which Constitution Amendment Act 1975 received assent of President shall, insofar as they are in conformity with provisions of this Constitution as amended by Constitution 36 Amendment Act 1975, be deemed for all purpose to have been valid, done or taken under this Constitution. Okay. Then there's this is Moseram 331G. So I'll stop here because I cannot read properly. Maybe I pronounce something. So we'll see now later on of this. We'll see this later on because already it's 1:25 and time is over and I will be feeling a little lazy. You can say that. So I close this video. What we wanted to discuss about these stories are temporary. Means we discuss about Jammu and Kashmir, we discuss about Maharashtra, we discuss about Nagaland, and we discuss about Sikkim and maybe one or two more. We'll take up in next video along with some more provisions within a constitution of India, which is the period of constitution, the name of country, and so many things are there. And then amendments and extras, all that we'll do. And means what more amendments are there, have been there, 100 more than 100 amendments. We'll discuss with that. This is purpose of this that people understand what is there in this. Means I'm not going to research it completely. I'm not asking this is just informative for informative purpose. This must be known to you, and that's very important, and nothing else. So I'm just closing down this video. Thank you very much for your time taken, and next time we'll meet you once again. Jai Bharat.